I'm going to talk today about some of my current work on the law relating to human trafficking, and that relates to my mandate, which is a UN mandate as Special Rapporteur in human trafficking. I'm happy to talk a little bit or answer any questions about how the UN special procedures work, the limits of our methods and ways of working, and also the opportunities there as well. And in particular, I think it's really important to remember that the resources that you have as researchers and academics are hugely important to the UN system, to the special procedures, treaty bodies and others in terms of trying to make those work more effectively and bringing concerns to their attention also, recognizing their limits as well. So just talking today then around human trafficking, the title is quite broad, Rethinking Law on Human Trafficking, and I'm just going to touch on 3 different areas that I'm currently working on in the UN mandate, and just thinking about the potential to make changes to transform human rights law and practice and the obstacles that are constantly faced and the limits of that work also. In the context of human trafficking law, then we have seen in recent years really a growing body of laws and policies at both domestic and international levels. And this has led to some concern and also critique, in particular from feminist commentators who've responded with concern to this proliferation of laws and to what some have expressed concern about as the expansion of sovereigntist power that has accompanied anti-trafficking measures, particularly in the context of migration. And so the unintended consequences of anti-trafficking agendas sometimes has included this expansion of state power to regulate border crossings, and often a further closing off of regular migration pathways for migrants. And when we see that the kind of intersecting axes of discrimination and power linked to gender, race and ethnicity, class, and migration status become marginalized in these responses. A kind of crisis governance response takes hold. And to borrow from Agamben, his evocative phrase, we have seen an explosion of laws and also in some contexts, a continuing circulation of moral panic, particularly in the context of trafficking for the purpose of sexual exploitation. And this crisis response can have negative consequences for migrants and for the longer term analysis of the substantive impact of anti-trafficking laws on the rights of migrants and on gender equality. And many would argue that the preoccupation with criminalization of trafficking and related activities has narrowed the possibility for responses that are really focused on protecting the human rights of migrants and more broadly protecting the human rights of victims of trafficking. So we see that while we've had on the one hand this explosion of laws relating to human trafficking, migration across borders is also becoming increasingly constrained and regulated. And a victim of trafficking, although recognized in international human rights law as a victim of a serious violation of human rights, an egregious harm, may also be perceived first and foremost as an irregular migrant in the eyes of the state. And so a migrant with a possible claim to international protection, as we know, poses a significant challenge to the state's claim to control who crosses its borders and remains within its territory. And so a victim of trafficking may be tainted with this perception of irregularity on the part of the state. And her potential claim to be here, to remain within the destination state is one, of course, that is contested and often resisted. And so while we can no longer say that citizenship status as such is equated with the right to have rights, states have proven reluctant to remedy what may be the fundamental irregularity of a victim of trafficking, her presence within the state, or to recognize a right to stay beyond short-term conditional residence. So within the European Union, for example, we even see continued attempts to apply the Dublin regulation, for example, to victims of trafficking applying for asylum. The question then, I guess, is whether this kind of ideological capture is complete, and what opportunities there might be to resist the expansion of the criminalization of migration, and to recognize instead the complexity of rights claims of victims of trafficking, and the relevance of wider human rights protections. We are seeing, albeit limited, some pushback, increasingly visible in incremental changes occurring in relation to residence permits, residence claims, recovery and reflection periods, restrictions on return of trafficked persons, as well as the recognition of positive duties to identify victims of trafficking, assist and provide protection, as well as providing effective remedies. So these are very incremental and limited changes, and they reflect a need to move beyond the kind of stereotypical portrayal of the abject victim that has frequently shaped law's responses to human trafficking. And that often leads to us overlooking or marginalizing the agency of the trafficked person. In the practice of human rights law, I think we can see some examples in the claiming and enactment of rights, where we see a potential to move beyond a kind of binary divide between a crisis governance response to human trafficking and a process that recognizes agency and complexity of the experiences of victims of trafficking. So to borrow from Diane Otto, we know that the institutionalization of feminist ideas, particularly in the context of crisis responses, always extracts a price of compromise and dilution. And I think the question then is whether this compromise ultimately damages the goals of securing equality. And we have to look at how are anti-trafficking measures working in practice? How are they evolving on the ground? And there, I think it's the question of who sponsors feminist goals matters a great deal. And that becomes very clear when we look at the genealogy and contemporary practice of anti-trafficking measures. A core motivating impulse continues to be a protective one, both at national and international levels. So we see repeatedly this normative reemergence of a protective impulse, which may limit the agency and mobility of a victim of trafficking, and also give support to a creeping expansion of the criminal law and of immigration control agendas. So to give us an example, we saw, for example, in the UK, reforms to the overseas domestic worker visa in 2012 were justified in part by an argument that the restrictions were necessary to prevent exploitation, including trafficking for the purpose of domestic servitude. And the calls for reform and resistance did lead to some changes in 2016, but there are still many limitations, many restrictions on the right to change employers, on the right to stay. So that claim, that political claim to combat modern slavery, to protect against exploitation, can be used in ways that in fact put in place conditions, laws, limitations that make migrant workers much more vulnerable. So if we look at the key international legal instrument was the Palermo Protocol adopted in 2000 on trafficking in persons. And this was a very significant moment in international law, the first accepted international legal definition of human trafficking. But that legal instrument, of course, was adopted as a protocol to the Convention on Transnational Organized Crime. So the particular preoccupation at that time was very much a shared interest between states in combating organized crime and in limiting irregular movements across borders. And we see much more limited attention given in the Palermo Protocol to the human rights claims of victims of trafficking. So all of the provisions relating to assistance to victims and protection are very limited, as states are required only to consider strengthening assistance measures to victims. And This failure to ensure stronger protections for victims of trafficking, of course, reflects a reluctance to recognize rights claims that arise in the context of migration and a continuing dominance of security and sovereignty concerns. Now, since then, we've seen significant developments in international and regional human rights law, the Council of Europe Convention on Action Against Trafficking, the 2011 EU Anti-Trafficking Directive. We've seen significant case law at the European Court of Human Rights and the Inter-American Court, a 2020 general recommendation on trafficking in persons from CEDAW, which has attracted quite a bit of criticism. But those are all now part of the developments of international human rights law. Looking then at how those play out in practice, I think we can see in particular in the advocacy and activism of women's rights organizations, of migrant workers organizations, of trade unions, we can see a potential to use laws relating to human trafficking to push back against that immigration control agenda, that criminalization of migration, and to see the potential for some, albeit limited, change. So I want to look first then that one of the landmark judgments of the European Court of Human Rights, which may be known to you, ransom in Cyprus and Russia. It was the first judgment of the court that recognized trafficking in persons as coming within the scope of Article 4 of the ECHR, the prohibition on slavery, servitude, forced or compulsory labor. And the case was pursued by the father of Oksana Rantsev, who had died while seeking to leave her situation, escape from her situation. And the case itself and the proceedings revealed systemic exploitation in the commercial sex industry in Cyprus. Rantsev's death itself was not attributed by the court to either of the respondent states, Cyprus and Russia, but the court did find a series of violations of the state's positive obligations. And I think it's that jurisprudence and positive obligations which is quite interesting. And the failures included failures to regulate employment in the so-called cabaret artiste industry, continuing to maintain a visa regime for cabaret artists that did not provide effective protection against exploitation, including trafficking in persons, and failing to carry out effective investigations into her death domestically or transnationally. The court said that trafficking in persons treats human beings as commodities to be bought and sold, and was incompatible with the democratic values of the Council of Europe. So it was the first time in which a state was found to be in violation of Article 4, specifically with regard to trafficking in persons. It followed on from the earlier case of Salviati versus France, which involved a young Togolese woman who was found to have been exploited in domestic servitude in France. And the Salviati judgment was also significant in recognizing that Article 4 could give rise to positive obligations, but it has been repeatedly criticized as failing to recognize that such obligations could extend to regularization of a victim's migration status, for example. So we see a continuing focus on criminal justice responses, and that fits very much within the predominantly prosecutorial model that has tended to shape international legal developments on human trafficking, and falls far short of a response that would recognize the range of human rights claims of victims of trafficking. We see some change, some progressive developments in the Council of Europe Convention on Action Against Trafficking, in the provision of recovering and reflecting periods, short residence periods, and in EU law. But within EU law, we see the continuing conditionality of residence permissions. So the 2004 directive, for example, specifically conditions the issuing of short-term residence permits on a victim of trafficking cooperating in criminal proceedings. And the 2011 anti-trafficking directive was adopted specifically with the intention to improve and strengthen assistance to victims, but is without prejudice to the provisions of the 2004 directive or similar national rules. So those remain in place. So we have this continuing conditionality and this failure to recognize the importance of secure residence for victims of trafficking. And also the associated risks of exploitation on the ground, reoccurring. Audrey Macklin, writing some time ago, has pointed out that if we're to take human trafficking seriously as a human rights violation, as the legal texts tell us, then we should admit the contributory role played by receiving countries and conceive of the host country, for example, as owing a victim of trafficking a remedy arising from the complicity in the violation of her human rights. So from this perspective, the option of secure immigration status could be viewed as a human rights remedy, as part of the right to an effective remedy, and not merely as an act of benevolence on the part of the host state, or as a contingent benefit, conditional upon cooperation with legal authorities in the prosecution of traffickers. In the ransom case, the European Court of Human Rights had no doubt that the Cypriot authorities were aware of the exploitation occurring under the guise of the cabaret artiste visa scheme, and that this was being used specifically for the purpose of exploitation. This is not unique, of course, to this instance. We can point to many other examples where destination states may be complicit in human trafficking by continuing to operate immigration schemes that significantly increase the vulnerability of migrants by limiting access to secure migration status. And again, secure immigration status would mitigate against a significant cause of the vulnerabilities that lead to trafficking and to exploitation. But it's not always top of the agenda of those who proclaim to prioritize combating modern slavery and trafficking as political priorities. Looking at other kind of developments in case law where we see the potential to recognize continuums of exploitation, a significant case coming from the court, I think from the European Court of Human Rights, is the Chowdhury judgment, Chowdhury and others versus Greece, which was the first judgment of the court to find a violation in relation to trafficking for the purpose of labor exploitation. And the court specifically found a violation of Article 4.2 of the convention in relation to 42 undocumented migrant workers from Bangladesh who'd been working on a strawberry farm in Manilada, Greece, and who the court found had been subject to trafficking for the purpose of labor exploitation. And it was quite an important judgment as it moved beyond the kind of stereotypical views of what constitutes trafficking. Recognize that even though there may be apparent freedom of movement, there may be still other subtle forms of coercion, including relating to migrant status, lack of knowledge of local conditions or language. So that was quite significant in and of itself, and also I think significant is the gender dimension, in that adult men were recognized as being victims of trafficking for the purpose of labor exploitation. And we see that gender dimension continuing to play out in difficulties faced by men and boys in being recognized and identified as victims of trafficking with claims to protection, whether in the context of labor exploitation, forced criminality, or sexual exploitation. And this is relevant also to the more recent case of VCLNAN versus the UK, which involved two Vietnamese boys who had been forced into cannabis cultivation, trafficking for the purpose of forced criminality in the UK, had not initially been identified as victims as such, but even then, when identified, the criminal proceedings continued against them, despite being vulnerable both as children and as victims of trafficking. So we see this difficulty in relation to the presumption around a stereotype of a particular type of victim. Labor exploitation in and of itself is less well recognized within the practice of international and regional human rights law on trafficking. That's linked to lesser recognition an acknowledgement of violations of socio-economic rights, weaker enforcement of labour standards and labour rights, and of ILO standards more generally. Both the VCL and the Chowdhury judgments try to push against that and bring greater visibility to who may be a victim of trafficking and to the range of types of exploitation occurring. But we see significant pushback from states and difficulties in moving forward in terms of ensuring implementation of judgments on the ground and structural changes. And I just want to look very briefly at one other area that has emerged as an area of concern in laws relating to human trafficking. If I can, this is the whole debate around the application of the principle of non-punishment. It was the subject of discussion by the European Court of Human Rights in the VCL case in relation to the Vietnamese boys. And the court found a violation of Article 4 of the Convention, but also Article 6, the right to a fair trial, and the breach by the state, in that case the UK, of its obligation of non-punishment. And non-punishment of a victim is something that has evolved in terms of developments within international law. It's not found within the Palermo Protocol. It was mentioned in the Office of the High Commissioner Principles and Guidelines on Trafficking. And it is found in the Council of Europe Convention on Action Against Trafficking and the EU Directive, but in quite a limited way. But at its core, it seeks to ensure that a victim of trafficking is not punished for unlawful acts committed as a consequence of trafficking. And that's quite broad intentionally in terms of its scope. It could include, for example, immigration-related offences, or what we see in some countries where sanctions are imposed, for example, for engaging in prostitution. The punishment of victims, of course, also goes directly against the proclaimed commitment to combating impunity for trafficking in persons, because it's targeting a victim of a human rights violation rather than the perpetrator. It's repeated again in the CEDAW General Recommendation adopted in 2020, which reiterates the importance of the non-punishment principle without exception, the obligation of states to ensure its application to all victims without exception. And of course, it's directly linked to the principle of non-discrimination. What we are seeing happening is increasingly an awareness of the range of forms of punishment that victims of trafficking may be subjected to, including arbitrary arrest and detention, so detention for extended periods of time, forced returns and refoulement, and arbitrary deprivation of citizenship, so citizenship stripping, family separation, and unfair trials. The Global Compact on Migration includes reference to the non-punishment principle in highlighting the obligation on states to facilitate access to justice and safe reporting without fear of detention, deportation, or penalty. But despite all of these calls, we see that implementation remains limited, and the scope of the non-punishment principle is very much contested. So the range of different forms of punishment has been the subject of a series of communications to states by UN special procedures over the last year, led by the Special Rapporteur on Counterterrorism, Fionnuala Ní Aoláin, including my mandate as Special Rapporteur on Trafficking, and a range of other UN mandates as well. And that has been specifically linked to the situation in northeast Syria, in detention camps and the conditions in those camps. And interestingly, from the perspective of the trafficking mandate, is the question of the obligation of states to ensure non-punishment of victims, and also positive obligations of identification, assistance, and protection. And that is the subject of proceedings currently pending before the European Court of Human Rights, the HM and HF versus France, and also proceedings before the UN Committee on the Rights of the Child, and has been the subject of a range of other proceedings at domestic level. The forms of punishment I mentioned can vary, including here, I would say, exclusion from refugee status may be perceived as a form of punishment, denial of welfare benefits, as I said, separation of families, and refusals of consular assistance. So this is something that we're seeing in the context of those detained in camps in northeast Syria. So a failure to provide consular assistance, a failure to ensure repatriation, or a suggestion that we could have repatriation of the children, but not the mother. And the deprivation, arbitrary deprivation of citizenship in and of itself as a form of punishment, as an administrative sanction that arguably violates the non-punishment principle, and also increases risks of exploitation, where somebody may end up in a situation of statelessness and all of the obligations violated in that regard, also in terms of reducing or combating statelessness. And it's interesting that the obligation of repatriation of victims of trafficking is one of the very few strict obligations on states in the Palermo Protocol in Article 8. So that obligation to repatriate victims of trafficking to countries of origin is actually a strict legal obligation in the Palermo Protocol. It's been the subject of much activism and advocacy by NGOs, including Reprieve, the International Human Rights NGO, who are engaging with states around this concern. And of course, what we see happening here is this kind of presumption that this is somehow outside of the scope of anti-trafficking law. That it doesn't fall within the recognized scope of anti-trafficking law, that those who are claiming to be victims or who it is argued are victims don't fit the ideal victim type, the stereotype of who may be a victim. One obvious case, of course, is in relation to Shamima Begum in the UK and the deprivation of citizenship that occurred there and the ongoing proceedings in relation to that. So having left the UK as a child, it is arguable that she is a victim of trafficking. The definition of trafficking requires act, recruitment, means and purpose, the purpose of exploitation. The means is not relevant where the victim is a child, and consent is irrelevant where the means are used in any case for adults. So given the context there, if she were to be recognized or others now detained in northeast Syria were recognized as victims of trafficking, that triggers very strict legal obligations, positive obligations on the part of the state under the ECHR, under Article 4, and even under the Palermo Protocol, which I said is quite light in terms of the obligations imposed on states with regard to assistance to victims. So here, I think we see again the potential for rethinking how human trafficking law operates and who it can and should apply to. But the resistance that we see reveals a discriminatory element, a reluctance not to apply those rights to all victims of trafficking without exception, which is the requirement with regard to the non-punishment principle. So we see an underpinning discriminatory practice there on the part of states and the responses by states. And appealing to human rights law seeks to challenge that, to bring forward that kind of claim. Whether or not it will be successful in securing change, it's unclear, but it brings forward a different claim to how law should or could operate. And finally, just want to note another ongoing area that's currently being challenged with regard to how human trafficking law operates. And that relates to the situation of domestic workers, in particular, those who may be exploited in diplomatic households. So this has been an ongoing problem for some time. It might be argued that this is actually, it is a very small proportion of those who are victims of trafficking, but normatively it's very significant in terms of recognizing limits on state sovereignty, and also given the importance that embassy missions are supposed to play in assisting migrant workers in preventing exploitation. It is significant to look at how laws on diplomatic and state immunity work with regard to trafficking in persons. So currently there are proceedings pending before the UK Supreme Court in the case of Basfar and Wong, looking specifically at the whole question of trafficking for the purpose of domestic servitude in a diplomatic household, and the question of the scope of diplomatic immunity. And interestingly, although state immunity has been recognized as limited in the employment context, diplomatic immunity is still considered to be much broader. So my mandate is intervening. There are other interveners as well, and it revisits a question that was previously before the Supreme Court, but not resolved. And of course, it's been the subject of litigation and debate in many other jurisdictions as well. And the question will be whether the court decides to recognize diplomatic immunity as necessarily limited in the light of human rights law developments. What Brenda Hale had previously described as positive developments in international law. It will also raise the question of whether trafficking for the purpose of domestic servitude is recognized as a commercial activity, which is one of the recognized exceptions to diplomatic immunity. And that raises the whole question of whether domestic work, domestic servitude as such is recognized as commercial activity. And again, the case law arising under Article 4, ECHR, and other developments in human rights law will be brought to bear to make that argument. So to conclude, just want to raise a few questions around how the law operates, how human rights law operates, what we see happening here in terms of changes and shifts in law relating and practice in relation to human trafficking. Do we see the law playing a kind of kettling role in terms of constraining the kinds of claims that are brought forward, enforcing these claims to fit into predetermined legal forms? Does it limit the impact on structural reforms and wider questions around labor protections, for example, or migration, safe and regular migration? Are we really just looking at an excitement around the exotic, combating modern slavery, but a reluctance to engage in questions around the everyday? So can we move beyond what Diane Otto had described as the kind of injured subjectivities that are produced in how law engages with victims of trafficking, in particular women and girls, I would say? So what is the potential, or is there the potential for human rights law to secure change in practice? So Benabib talks quite a bit about this, of course, around the jurisgenerative effects of lawmaking, of rights enactment, of bringing forward human rights claims, producing new vocabularies of public claim making. But as against that, of course, you constantly have these processes of de-juridification, of exclusions, of limits, of exceptions. The domestic work one is one example. Appeals to national security, another, of trying to push back against those expansive claims. I would argue that rights claimants can bring forward different kinds of claims, can bring forward different conceptions of the law, different kinds of human rights claims. And the purpose behind that is to try to claim and invoke the universality that is supposed to underpin human rights law. So move beyond what we see in practice as being limits, exceptions, exclusions that are rooted in discrimination. But there is the potential to push back against those and to constantly make those claims, always recognizing the limits, I think, of the outcomes. That's all. Thank you.